prolong your curiosity and participate in this discussion. Let's speak about what is surveillance. Next slide, please. Oh, I have a clicker, sorry. Yeah. Let's speak about what is surveillance. Maybe I'll move around a little bit because I feel very weird to be stationary at a place. What is surveillance? Surveillance is continuous monitoring of a person's movement, a person's asset like a person's phone, computer, or the public places where the person can move around, right? Surveillance is continuous monitoring of a person's movement, his place, and his whereabouts. Now, surveillance can be intrusive, right? Imagine that you're sitting in the auditorium today and somebody is constantly watching you throughout this session. How would you feel, right? Your movement will be constricted. You will feel a little conscious about how you speak, how you move, right? Because a person watching over your shoulder is the last thing that anyone can have. But I'm audible, right? Okay. Thank you. So a person being watched continuously is not the most pleasant thing, right? But the government has the rights to survey us, right? But that right is not something that is guaranteed under the Indian Constitution, or rather there are restrictions around how government can watch us. So if you think about surveillance and surveillance of people, different classes of people, a lot of judgments come to our mind, right? Sometimes it's your thoughts that can get you in trouble. You will all recollect Professor Sai Baba's case where he was alleged of Maoist links, but he was then acquitted by the Supreme Court. He, after the release, said that he was prosecuted and imprisoned for his thoughts. Not because he did something or did anything wrong, but for his thoughts he was imprisoned. Imagine the world where we will be imprisoned or tried because of the thoughts we have. That will be truly anarchy or statelessness, right? So surveillance can be an intrusive form of restriction on our fundamental rights guaranteed under the Constitution. And that's why surveillance cannot be absolute, and there needs to be standards regulating a surveillance, right? So what are the fundamental rights that are impacted? Sorry, tech issues. So what are the fundamental rights that are impacted? Let's speak about Article 19 and 21, right? You all will recollect Article 91. 19, I don't have to go into details, but let me tell you what Article 19 is. Article 19 guarantees certain type of freedom, right? Freedom of speech and expression, freedom to move around, freedom to form associations, trade unions, cooperative unions, and also freedom to peaceably assemble. These are all freedoms that is guaranteed to us under the Constitution, right? And Article 21, as you would recollect, no person shall be deprived of their personal life or liberty except by procedures established by law. These are fundamental rights guaranteed to the Constitution. So if these are fundamental rights, what does it mean? We can approach the Supreme Court directly under Article 32 if these fundamental rights are violated, right? These are part of the basic structure of the Constitution. After Kesavananda Bharati's case, it was held that the Golden Triangle, Article 14, 19, and Article 21, is the basic structure of the Constitution, and these are inalienable rights of the citizens of the country, and it cannot be removed by a judicial order or by a legislative order. It cannot be. These are inalienable rights of the people of the country, right? So that's what Article says. But an important question to ask under Article 19 and 21 is that these are not absolute rights. The government has powers to regulate these rights by passing a law and can restrict these rights, and the standards that is expected of the government is that these restrictions needs to be always reasonable and should be for certain specific causes, right? If we broadly speak about Article 91, the reasonable restrictions should be for protecting national security or protecting public order. I know those terms are broad, right? Anything these days can be public order, and anything these days can be national security, and there has been several instances of misuse by the government. But the Constitution, when it drafted it, the sense in which it was drafted by a Constitutional Assembly members is that these are fundamental rights, only reasonable restrictions can be levied on them on the grounds of national security and public order. Now, what does Article 21 say? Little recap, right? No person shall be deprived of their life or personal liberty except by procedures established by law. So what does it mean? Can it be any law? Can the legislature tomorrow string some words together and pass the law and say that you don't have Article 19 and 21 like they did during the times of emergency? No. This law should not be just mere letters of law. It should be just, fair, and reasonable, which you would all recollect that we borrowed from the US Constitution something called due process of law. So it's not any law that can take away your fundamental rights, but that law should be just, fair, and reasonable. That is the due process established by the Supreme Court in Manikya Gandhi's case, right? You would recollect in A.K. Jabalpur's case, the Supreme Court said the fundamental rights should be read in silos and can be suspended by the executive, by the parliament, right? It was only Justice H.R. Khanna, the sole dissent, who said that fundamental rights are inalienable and cannot be suspended by mere letters of the law. And it's Justice H.R. Khanna's, sheer courage and bravery that costed him the elevation at the Supreme Court. But he is the person who stood with the Constitution at that time, and that later became the majority judgment later in Manikya Gandhi's case, where the Supreme Court unanimously held that the law should be just, fair, and reasonable. That is the due process clause, right? So even surveillance can be seen as a restriction on Article 19 and 21. And that restriction can be levied by the government by a law which is just, fair, and reasonable, right? That's the standard. Now let's delve into a few certain specific precedents that's relevant for surveillance. In Karak Singh's case, the UP government authorized domiciliary visits. Domiciliary visits meaning visits to a person's house in the night. The Supreme Court said in that case, which was in 1960s, said that citizens of India do not have a fundamental right to privacy under Article 21 of the Indian Constitution. This is what the Supreme Court said, right, in 1960. But it struck down the domiciliary visits, stating that a person's house is more of sanctum sanctorum to that person. In Latin terms, that means a person's sacred place where he should be having his own privacy and the state cannot alienate it, and struck down the domiciliary visit, not because privacy was fundamental right, it is because it violated the personal liberty clause under Article 21, right? It was in Karak Singh's case that the Supreme Court specifically dealt with the question of whether privacy is a fundamental right and disagreed with it and said no citizen in India has fundamental right to privacy. So there was a dissenting judgment there as well. As you can see, I'm a fan of dissenting judgments, right? These are the judges who have thought ahead of the time and which became majority law in the future. Justice Subbarao in Karak Singh specifically held that if a person is monitored every minute of his day, then how can he have intellectual freedom? How can he think about thoughts that can be found unacceptable by the government? He should be left to his own, where his intellectual abilities and intellectual associations can flourish, and where he can form an informed opinion about the government when he left alone. So any type of intrusion into his privacy, about his thoughts, about his movements, is violative of the Constitution, is what he held, right? Then later it became the law, but it was Justice Subbarao who, in the dissenting opinion in 1960, said it is not the place that we should focus on. It doesn't matter if a person is in his house or if a person is in public place. We should give importance to the individual, a person's personal right to privacy, irrespective of the place where he is, right? Even now we are in a public place, but that doesn't mean that we have submitted our right to privacy to the organizing committee of this event. You all have individual right to privacy, right? Just because we are in a public place doesn't mean that somebody could intrude our privacy rights. That's what Justice Subbarao said in his dissenting opinion. That was in 1960s. Now, surveillance as a concept of whether it violates privacy rights also evolved, right? We can see in PUCL case, there were indiscriminate phone tapping orders that was issued against PUCL. You will all recollect that PUCL is a very renowned NGO which works on civil rights protections and everything. It was their phone that was tapped by the CBA for indiscriminate amount of time. So they approached the Supreme Court and challenged it, right? The Supreme Court said that indiscriminate phone tapping is violative of Article 19 and Article 21 of the Constitution. But again, decided that a person doesn't have a fundamental right, that is right to privacy under Article 21 of the Constitution. I'll just take a quick break. So it was the PUCL case where again the Supreme Court considered whether there is right to privacy is a fundamental right under Article 21 of the Indian Constitution and refused to do so, but had issued specific orders on how surveillance such as phone tapping can be executed, right? It cannot be for an indiscriminate period of time. There should be a supervisory body which reviews these phone orders. It should be for a maximum period of 2 months, only with judicial consent or judicial approval. It can be extended to a maximum period of 6 months, and it cannot be all phones in the PUCL office. It could be specific phones that is necessary for the purpose of preventing any national security or public order situation, right? You can see how the judgments have evolved from Karak Singh's case. Though the Supreme Court did not guarantee privacy as a fundamental right, it made a step further in recognizing that surveillance can be inherently intrusive and laid down guidelines on how phone tapping can be made. Right, that's PUCL case. You will see further involvement in Selvi in 2010 Supreme Court decision, where the Supreme Court specifically held that any polygraph or brain mapping test that is done without the consent of the person who's being subjected to it is inherently violative of the Indian Constitution. It said it's violative of Article 20, Clause 3, which you will recollect, which is the right against self-incrimination, which is proven innocent until guilty clause under the Constitution, and Article 19 and 21 of the Constitution. So in Selvi's case, it was held that any brain mapping or polygraph test is without the consent of the person being subjected to it, is inherently violative of the Constitution, right? I also want to sum it up around what is polygraph and brain mapping. As you will all know, brain mapping or polygraph cannot determine the guilt of a person. It is not an evidence that is considered to determine the guilt of a person. It is only going to be an additional evidence where it can be used to understand if there are additional facts that may be relevant for the investigation. For example, in the brain mapping test, if a person says that the murder weapon can be found across the river nearby, that fact can be used as a relevant fact for the investigation. But if there is a coercive statement that was made during the brain mapping or polygraph test, that is not an admissible piece of evidence and it is violative of the Constitution, right? Just to jog your memory around how polygraph tests can be employed and how it doesn't determine the guilt of a person. It's only an additional evidence, it's a corroborative evidence and cannot be used alone, right? In Selvi's case, the Supreme Court specifically said coercive use of these techniques is violative of the Constitution. So you can see the evolvement, right? From Karak Singh's case to phone tapping to polygraph, the Supreme Court has definitely evolved to say that privacy is increasingly becoming an important right, and any surveillance that takes away the right to privacy needs to be done in a measured way where the executive applies its mind, it's reasonable, it's restrictive, and it's done judiciously, right? That's how you can see this doctrine evolving a bit. Now we are going to go to a pivotal moment in time where the 9-judge bench of the Supreme Court declared that privacy is a fundamental right guaranteed to the citizens of India under Article 21 of the Constitution, right? We will spend some substantial time on Punnaswamy's judgment because it's going to be a pivotal point for our discussion today. Now, how did it all happen, right? In 2017, it really took so many years, more than 50 years of independence for the Supreme Court to decide that right to privacy is a fundamental right under the Indian Constitution, and it happened in 2017-18. How did we get there? These were a batch of petitions that you will all recollect challenging Aadhaar, right? There was an implementation of Aadhaar by the government. These were the batch of petitions that were challenging that reached the Supreme Court, the 3 to 5 judge bench, and finally the 5-judge bench referred this case to a 9-judge bench in Punnaswamy's judgment, where the Supreme Court held that right to privacy is a fundamental right under the Indian Constitution. What does it mean? It cannot be, the government cannot, the state cannot deprive a person of this right. If it's going to restrict the right to privacy, it can be done only by procedures established by law, which is just, fair and reasonable, right? That's the elevation status we are getting there. It's no more an ancillary right, but a fundamental right. That's what the Supreme Court said. It's very interesting. So, it's a 500-page judgment. I know that can be a lot to read these days, and I also would like to point out, it's not a unanimous decision like I've stated there, but it's a decision that was given by 4 judges. There were 4 written judgments. Justice Chandrachud represented 4 other judges, and 4 other judges wrote separate judgments on why right to privacy is a fundamental right. I know that's an academic fact, but I tell you why it's important. If you read the whole judgment together, there is a very informative article by a lawyer called Gautam Bhatia in Live Law. You should look at this article. It's written in 5 parts. It will tell you the different facets of privacy that is recognized under the Indian Constitution. Let me touch upon 2 important facets of right to privacy that is relevant for our discussion. The first facet being every person is entitled to privacy as a fundamental right, right? What does it mean? It also means a person has right to self-determination. What does right to self-determination mean? Right to self-determination means a person's right to the food that they eat, the choice of food that they eat. Can you eat beef or not? For example, a person's choice to wear the clothes that a person wants to wear. A person's choice to fall in love with the person that they want to, a person's choice to marry someone that they would like to, right? It's these fundamental rights to self-determine who you want to be. That is covered under right to privacy under Article 21 because of this judgment. The second facet of the judgment that is relevant is that informational privacy. Now, for example, a lot of data of all of us is being collected by the government and corporates, right? It has different facets of data. For example, you use cell phone, you use computer, now you use generative AI, you use Facebook, Instagram, so many social media websites, you shop from so many websites. There is this host of data that is being collected both by corporates and the governments across all of us, right? If you put the metadata together, there will be an individual profile for each one of us that is somewhere residing in the cloud, right? If somebody wants to target me for an advertisement, they will know that I'm age group between 25 to 35. I buy certain types of products, I live in a certain type of region, I use certain type of cars for my commute, I use certain type of tickets or prefer one airline over the other, right? The entire set of data of me, of a digital footprint is available. Now with all of this data, right, we have been targeted for advertisements. The government could use this data. What does it mean? The Supreme Court wants the government to enact a law that protects each one of our data. Right? When can these data be collected? Is it collected with your consent? How are these data processed? Can this data be deleted after a period of time? Do you all have a right to be forgotten, right? We are omnipresent in this social media age. So much of our information is available online. If you choose to withdraw being present in this world, can you do that? Do you have a right to be forgotten from the social media age? Those type of issues should be legislated, is what the Supreme Court said. The Supreme Court said every citizen of India, actually Article 21 applies to every person, right, who resides in India. It could be any person. It applies to everyone, and the government should enact a specific law or in any other means protect a person's informational privacy. That is, how is your data being collected, stored, deleted, processed. All of this should be regulated by the government, is what the Supreme Court said. So when you think about privacy, you will think about, yes, nobody should monitor my phone or nobody should monitor my belongings. It could be that. But the Supreme Court went ahead and thought about it and said you have both right to self-determine yourself, which is what food you eat, what will you wear, where will you travel, who you can fall in love with, and your informational privacy. That is, how can your data be used by the government and corporates. The Supreme Court guaranteed both of these rights in Puraswamy, and this informational right to privacy is very relevant for our discussion on AI surveillance. We'll come to that in a bit, right? So this is the pivotal point. It's called the Supreme Court almost offered a constitutional spine to right to privacy because of this judgment, must-read judgment. Now the court also went ahead to lay down some tests, right? A doctrine called doctrine of proportionality. We'll get into that detail. So if the government wants to restrict your right to privacy, it can do so, but it has to follow this test that is laid down in Puraswamy's case. What is this test? There should be a legitimate aim. If it's going to be restricting your privacy, it cannot be for any event. There should be an extraordinary circumstance necessitating that surveillance, right? There should be a law regulating on how your privacy can be restricted. So there should be a legitimate aim with the backing of the law for the government to restrict your right to privacy. The second prompt test is rational nexus, right? For example, if the government wants to tap a person's phone, let's say one among you, right? And there should be a reason on why you're being selected for your phone being tapped. Are you a person who's suspected of a crime? Are you someone who's suspected of starting a riot? Does the government have facts to believe that you are in a specific place that puts you in a position for your phone to be tapped? Are there antecedents? Do you have connections with people who are already convicted criminals? There should be a rational nexus on why a person being chosen for his phone or her phone to be tapped. There should be a rational nexus on why the tapping needs to be allowed, right? Then it should be a necessary step. For example, if it's not phone tapping, can physical monitoring you as a person, would that suffice for the purposes? Then that should be chosen, right? If there is a least restrictive measure that is available for surveillance, then that should be chosen versus something that is inherently intrusive like phone tapping. And the last prong of the test is the proportionality. That is, the benefit of tapping your phone, for example, should outweigh the risks of restricting your fundamental right. The government needs to show that only by tapping your phone, they were able to prevent a right from happening, for example, right? Or any public order issue or national security issue. It cannot be a strict sense of, tapping everyone's phone in the region. If there is a right that is taking place, imagine a situation, it cannot be 100 people were there and their phones were tapped. There should be a reason of why you chose the 50 people of the 100 people. First, you need to be specific about whose phones to be tapped and why that was necessary to prevent a crime or a right from happening, for example. So the benefits of tapping your phone, which is a surveillance measure, should outweigh the risk of restricting your fundamental right? That's the four-pronged test, right? It's worth going over that once again. There should be a legitimate aim with legal backing on why a surveillance measure is used, right? There should be a rational nexus on why that method is used. We need to explore if there is a least alternative measure that is available without surveillance, then that should be preferred. And then finally, the benefits should outweigh the risk of restricting your fundamental right. That's the four-pronged test, right? This is the pivotal point in which these tests are employed by the Supreme Courts and High Courts. It's been 7 or 8 years since this judgment was passed, right? We can analyze few judgments on how Puttaswamy is being applied. We can think about it a little bit later, but this is a good time for us to think about how 7-8 years of Puttaswamy has changed our right to privacy implementation under the Indian Constitution. We'll get to that. I know it's already like half time. It's worth recapping. We spoke about what is surveillance, why is it intrusive, what are the fundamental rights that are implicated, how privacy became a fundamental right under Article 21 of the Constitution, and if it has to be restricted, then what is the test that should be employed? That is what we covered until now. Now let's talk about AI surveillance, right? More specific to the topic. I'm sure AI is your favorite topic and you're thinking about what is AI. So I'm going to share with you on what I think about AI and what is AI, right? We're talking about AI surveillance in this section, but let's take a step back and understand what is AI, right? Artificial intelligence is a computational system, right? It learns based on the data that you provide them. It learns the data, it starts recognizing them, predicting them, organizing them, and then performs the tasks that you give them with minimal supervision. That is what AI is, right? We speak about AI more now versus before. That's because we have generative AI. That is, the generative AI can respond to you by voice, text, audio, and it's available on a mobile phone, right? That's why generative AI is widely spoken about now, and it's a buzzword. But that doesn't mean that AI did not exist before, right? AI, or what they call in technical terms as machine learning, has existed for more than a decade, right? Think about weather forecasts. Will it rain today? That is being done by AI, and that is done for more than a decade now using AI. Understanding the prediction of what is the wind pattern, is there humidity, is there a storm that's coming along Bay of Bengal, for example, right? That is being used in weather forecasts. If you look at corporate companies, they do their sales, product predictions using AI and machine learning. So machine learning is nothing but the computer taking your instructions and then performing your tasks based on the instructions that you provided them, and that's what artificial intelligence is. So what changed? Why do we all speak about artificial intelligence now versus before, right? That's because now artificial intelligence is powered by neural networks that mimics the pattern of our brain, right? Now AI can think like our brain and perform tasks in a multimodal way. You would have seen, right? You can speak to the AI by voice, you can ask them to generate images, you can ask AI to make you videos, presentation. It has become multimodal. It's no more the XY01 binary language. It can understand different types of commands in different type of modal facilities for it to perform tasks, like a human brain, right? It takes the data, it processes it, it analyzes it, and it performs the task that it provides you. That is what has changed. Now, AI is powered by neural networks that mimics the functioning of our brain. That's why it's being widely used, and the generative AI has become more democratic and accessible to all of us. That's why we speak about AI more than ever before. So don't think about AI as only ChatGPT, Gamma, Grok, and DeepSeek, but think about AI as anything which is capable of machine learning based on the instructions provided by it, and which performs your tasks with minimal supervision. That is AI, right? That is AI. Now, what is AI surveillance? I'll give you examples of how AI surveillance is used all around the globe that I have witnessed personally, right? AI surveillance can change the game of how surveillance is used. I'll give you an example I'll give you a mock example and tell you how, AI surveillance is even more intrusive than regular surveillance, okay? Let's consider a hypothetical scenario. Let's take there is a bomb threat in this auditorium right now. Don't panic, okay? It's only a threat. It's a hypothetical situation. Imagine there is a bomb threat now in this auditorium, right? What does traditional surveillance do? Traditional surveillance would mean we check. Organizing committee members, probably the guests would also be put into that position. We will check all the exit and entry points of this auditorium. We will check if there are cameras, right? We will see if there is any CCTV camera. We think about who are the attendees of this event. We will compare that with, do they feature in any of the sanctions lists of the government? We will manually check them, right? We might bring in canines, dogs, and squads to check and see if there is an actual threat, right? Imagine there are 10 cameras. Then a couple of person or 3 people checking it should look at each camera individually and understand if there is a suspicious person moving from point X to point Y and what dress that person is wearing, how he is moving. But imagine that we can superpower this with AI. If you use an AI model, right, you don't have to look at each of the camera 10 times, 10 different individuals or 2 different individuals, each camera taking that time to analyze it. AI can look at the camera for you, all the 10 cameras at one time. It can process the data. It can understand your facial features. It can understand the patterns of clothes that you're wearing. It can understand your gait, that is the way you move. If a person moves with the front leg in a way that it takes him ahead with his left leg lagging behind, it can assess that pattern. It can move, it can notice your gait, it can notice your facial structures, your clothes, and how you're moving. And if you're in the suspicious point for more than over a few minutes, and give you an analysis in real time of who could be the suspected individuals, which a manual work would take hours, if not days, for us to put together. You will all be asked to stay inside until this analysis is over, until the bomb squad come and everything. But before the bomb squad comes in, if you use artificial intelligence, it would be able to process, analyze data with minimal time and in real time, right? Now let's come to whether it will be accurate in a minute, but it would be able to process data with minimal human supervision in real time, right? It can take the data, process it, categorize it, and even give you a list of suspected individuals. What type of data can it leap on to find if you're suspicious, right? It can look at your social media posts, if you have been posting insidery statements. It can look at criminal records to see if you have ever been arrested at the same time, right? It can match your facial features here versus any other camera that was recorded on your way to your college. It can look at those CCTV cameras that led you to the college. It can look at that data, all of that in real time, right? And then give you a prediction of out of the 100 people here, who are the 20 people who look suspicious and who should be interrogated, right? All in real time. That's why it changes the game on how surveillance can be used. It can happen, process data, give you results in real time. And when it does that, that's when it becomes over-intrusive, right? I told you I'll come to accuracy later. What did I mean? Though AI can perform all of this tasks with minimal supervision, the accuracy of AI is not at the place where we would like it to be, right? I'll give you certain studies. In an MIT Stanford study that was conducted recently, it was found that AI cannot find the facial features of black people with accuracy. That is, if you give them two black people, it cannot find the difference between the facial features of two black people. But it can do that with less than 1% error if it's a white man, for example, right? When it comes to black population, AI is still not equipped to understand different facial features. In fact, AI cannot even understand the facial features between a man and a woman among the black population. So what happens? If we use that tool to find we are all brown population here, probably its prediction is going to be wrong and someone innocent could be held back for an investigation, right? That danger is real. Imagine that you are at the mercy of an imperfect AI tool and you should be subjected and your right to privacy will be violated. Imagine that situation. That will be truly anarchical and statelessness, right? So that's one danger. It is not equipped to understand facial features of all populations, specifically us, black population. Second, there's another study which was conducted by Stanford and MIT, which found out that when it comes to voice recognition, right, AI can recognize voice of white people with 19% error. Bear with me, it's 19% error. This study was conducted just a year back. When it comes to voice of black population, the error was more than 45%. So if me and my husband are talking today, then probably AI would not be able to distinguish whether who is male or female by the first study. By the second study, the words that we use could also not be recognized by AI. That's the state of affairs that which AI tools are currently in, right? It is not able to understand the voice of black population. The accuracy rate is less than 70%, which means innocent population can be subject to trial. Then the other issue with AI is the biases that we as a society have today, right? Think about it. Who are the population that is rotting in jail as under-trial prisoners? It's the socio-economically poor people, it's the less privileged people who are prisoners in India, right? Now, if you feed AI with our criminal records of people who are in jail, then AI could predict that it is those population who are susceptible to commit a crime. Is it scientific? Just because someone from a socio-backward community had committed a crime or alleged to have committed a crime and an under-trial prisoner, and if they happen to be from a specific community and that's the data that you feed into AI, imagine the results. Just because you could be part of that community, you could be subjected to the doubt that you are a person who is susceptible of committing a crime. We all as a society have inherent biases. The caste system in the country has given us discrimination starting from our birth, right? So all of these biases, when it's fed into AI, the results can be exacerbated and your right to privacy can be taken away by an imperfect tool which is filled with biases. I'll give you an example. There was a study that was done in the US. During the evening time, the number of black people who were stopped by the police patrol were less in number versus number of black people who were stopped during the morning hours. Can you guess why? Because in the dark, the police were not able to distinguish which race was driving the car. Is it the black or white people? So black people were more likely to be stopped by a police patrol in the morning because they are more visible. In the night, it's difficult for the police to distinguish between white and black people, so black people were not stopped. This is the bias that we all inherently have as a society. Imagine that the US government in state of California develops an AI tool which gives the police officers a prediction pattern on who could be stopped for a crime. If this data is fed into AI, who will be stopped for a police patrol? It's the black guys who will be stopped. Because the inherent data has biases against black people in the US, for example. Bear with me that I'm citing all the studies in the US because that's where AI biases is being tested actively as we speak. So why AI surveillance cannot be used? Because its accuracy is not at the level we want it to be, and it can be filled with existing biases that can exacerbate the situation and put the right to privacy under risk under the Indian Constitution, right? That's why AI surveillance can be more intrusive than your normal techniques of surveillance that we have currently. We spoke about AI surveillance, right? Now let's think about how will it, I'll just check how I'm doing on time and I'm okay. I'm okay on time? So as we spoke about AI, it's more intrusive than normal surveillance, right? And it can profile people at scale. It can be filled with biases, which means innocent people can be tried even for their thoughts or movement, or people who they can be associated with, right? So it's inherently intrusive. Now, can AI surveillance stand the test of doctrine of proportionality laid down in Puttaswamy case is the discussion that we are going to have, right? Whenever there is going to be AI surveillance, remember the four-pronged test. We need to ask, is there a law backing that surveillance? Is there a rational nexus needing that surveillance? Can a least restrictive measure be employed for surveillance? Is it necessary? And lastly, does the benefit outweigh the risk? All of this four part of the test needs to be applied before we could employ AI surveillance, right? That is the standing law. Let's take a step back, like I promised you, to think about how does Justice Puttaswamy's case, right, in 2017, how has it fared? How has it been implemented in the last 7 to 8 years? Let's think about it for a moment, right? Though Puttaswamy case said that privacy is fundamental right under the Indian Constitution under Article 21, we can only give a mixed report when it comes to ranking of the judiciary on it. Think about the case where the Supreme Court held adultery is unconstitutional, right? It respected Puttaswamy's case and said a woman has bodily right over whom she chooses to have sex with, even if she is married. So punishing her for adultery is inherently violative of the Constitution. The court used Puttaswamy's judgment and upheld a woman's right to her own bodily autonomy in that case. In the case where the same-sex couple were criminalized, right, Section 377 of IPC was held unconstitutional, relying on Puttaswamy's case. There was another judgment where a single woman wanted to terminate her pregnancy, and that was not allowed for various reasons of how, all the societal biases of how women should carry the baby, women cannot harm the baby, but her right over her bodily autonomy on whether she should choose to carry the baby was not considered. The Supreme Court relied on Puttaswamy and allowed the woman to terminate, the single woman to terminate her pregnancy, right? All of that, good employment of Puttaswamy's case. Think about some other cases where Puttaswamy's case was not applied. Think about the case where there was a petition to criminalize marital rape. That's still pending. I have not last checked. But marital rape is not a crime even now in India, right? Where does the women bodily autonomy go there? Justice Puttaswamy's case was not applied. In a Rajasthan's High Court case, voice samples of a person who's doubted to have committed a crime was compelled. Selvi's case was not followed. Justice Puttaswamy's case was not followed. The court said voice is a personal trait and not a private, not something that is relating to privacy right? Absurd argument, but there Puttaswamy's judgment was not employed fairly, right? There are many other cases where Justice Puttaswamy's case was not employed and privacy right was not respected. So if we have to leave AI surveillance to the mercy of the judiciary, right, the Supreme Court and High Court, we can only get mixed results because Justice Puttaswamy's case is not being applied uniformly and liberally by the Supreme Court. So what is the solution? We cannot just go by doctrine of proportionality in the Puttaswamy's case. So what could be the solution? That's what we are going to talk about now, right? When it comes to AI surveillance, that is inherently intrusive. I promise this is the last time. Which is inherently intrusive, right? AI is inherently intrusive and AI surveillance can be inherently intrusive. So when it comes to that, then what should we do? We cannot just rely on one Supreme Court judgment, right? What the Indian government should do. Let's think about what other governments are doing. For example, right? In the EU, there is EU AI Act, which protects the privacy rights of people. In fact, biometrics such as fingerprints, DNA profiling in public places is considered to be illegal unless there is court order from the Supreme Court, right? So EU AI Act protects the citizens of the country who can deny to give biometrics in public places or identify themselves in public places. If you traveled in Europe, you will notice how many CCTV cameras are really around. You will hardly spot any. But if you just travel in Chennai from one road to other, you will spot how many cameras are here, right? Just because we have allowed people to put CCTV cameras doesn't mean we have surrendered our right to privacy to these third parties. I want to remind you that, right? In Europe, the government respects the people's privacy so much that CCTV cameras are hard to find in public places, and EU AI Act recognizes, again, the right to privacy when it comes to AI surveillance. What else does it do? In the UK, there is a method called double block test. That is, if a surveillance measure needs to be used, it's not just the police which decides it. There's going to be a quasi-judicial body that will approve the surveillance order. And the quasi-judicial body could be be a sitting or a retired High Court judge, cyber expert, right, and the police who will determine whether surveillance is necessary. It's not just up to the executive to decide on surveillance, but the judiciary should also be involved before, right? This is not post employing AI surveillance. This is before employing AI surveillance. Quasi-judicial body should be constituted, and that needs to be approved. That's something called double lock test under the UK, double protection. And under the US, there is no uniform law. It varies by the state. California has better state privacy rights than other states, but judicial warrants is mandatory for any type of surveillance. Forget AI, right? Phone tapping or GPS or anything, a judicial warrant, a prior judicial warrant is necessary. What can we learn from these jurisdictions, right? There is a solid law, at least in the EU, right, regulating AI. There is judicial supervision when it comes to surveillance, and there are additional protections about the government asked to be published what type of surveillance that they use, right? EU Act also mandates the government to publish monthly reports on the type of surveillance that they use on their population and what did they use these reports for, so that people can understand if the surveillance is in fact useful or not, or the government just prying on people, right? This type of accountability is being built under the legislative framework. We can learn from that. In India, we have a Digital Protection Act. It's not even enforced. There's no privacy board form. It was enacted in 2023. Only rules were notified, but it's still non-functional, right? It will be interesting for you to know that the Digital Protection Act exempts the Indian government. So if the Indian government process your personal data, it's not subject to the Digital Protection Act. So any regulation which tells companies about how to collect your data, process your data, or delete your data, it doesn't apply to the Indian government, who is the largest consumer of your private data. It's sad that the government chose to exempt itself from that, which is not an ideal measure. So if there is a legislation of regulating people's privacy and understanding whether AI surveillance can restrict people's privacy, then the government should be subject to that legislation and cannot be exempted from it, right? That's what we can learn from these jurisdictions. Backing off law, least restrictive measure, accountability measures such as reports being published so people can know if the surveillance method is used for legitimate purpose, and government being subject to that regulation, right? Those are the 4 broad recommendations I have when it comes for AI surveillance. With that, I will rather conclude my longest speech. Hopefully it was informative and useful. We can stop there and take any questions.
Now the session is open for questions.
And you spoke about the private side. I'm Mohan Priya from Government Law College, Seraman. And you spoke about the privacy, but in the recent judgments of the Supreme Court in divorce case or marital disputes, they can use the messages of the one party as against the other one. What's your opinion about that matter?
Correct, good question. So now, privacy is not privacy is a fundamental right. Reasonable restrictions can be imposed. That's the standard, right? But when it comes to marital disputes, private messages can be an essential evidentiary point, right? But I think coach, and we can all see how it is being done in practice. It's easy for me to say that private messages should not be considered, but it has evidentiary value. But we can also see how it is specifically used against women in a divorce proceedings, which is supposed to be more intrusive for women than men in our society, right? So when that is being done, caution should be exercised, whether do we have in-trial proceedings or more caution should be exercised by the judges while exposing private messages is my humble opinion. Thank you for raising it.
Another question, ma'am. As we use AI, the private messages of us is also included in that AI, which is which has been verified by that sources of the AI. Then what is the need to have the right to privacy in that one? It's against against the rights of privacy. Then what's your opinion about that?
Very good point. So we should all have a session on how to responsibly use AI. Do not provide your private information to AI. If it's a private information, use the necessary settings such as temporary chat in ChatGPT before you can give your private information, right? We should definitely take some measures on how to protect our data, but it's not just up to us, right? The government should enact an AI responsible legislation asking the AI providers to encrypt all the messages that is being provided and also regulated, and also store the data responsibly and delete the data after a specific usage, right? The government should also step in, but I would recommend that all of you take a responsible AI training. There are hundreds of courses available online, and do not feed your personal data into generative AI directly. Thank you.
Good morning, ma'am. I am Harni from Government of Salem, ma'am.
Hi.
So, how can you suggest, how can we constitutionally concile the state's duty and individual rights, especially the state's duty to protect the nation interest and public order and individual's rights to privacy as affirmed in Swami's case? And if the disproportionality of the AI surveillance impacted unjustly the marginalized community,
Yes.
is a constitutional amendment needed, or a sufficient legislation needed, or a judicial interpretation of the existing right is sufficient?
Very, very good question. I think it's combination of all. We definitely need an AI-specific legislation on how AI surveillance can be used. I would like to quote Lord Atkins. It's an old judgment. When it comes to national security, judges are more executive than executives themselves, is what he said, right? National security is so broadly used by the Supreme Court judges these days. So national security interpretation should be narrowed. The government should stand the test of what really is security. There should be a legislation mandating the government in publishing monthly or quarterly reports on what surveillance that it takes on us and what is the success rate of that surveillance. So it's combination of all. There needs to be legislation. Judiciary should also interpret national security more narrowly, and there should also be transparency requirement mandating the government to provide these transparency reports to everyone. Thank you.
Good morning, ma'am. I am Shakram Kumar from Government Law College, Karakudi. Your session was very informative and we are happy about it. And my question is about ethical dilemma between using ChatGPT for case analysis or mood preparations. Our professors suggest that we should not rely on ChatGPT. But when it comes to a totally different topic where we are not much informed or not well aware of the things, we are just searching things from ChatGPT, and then of course we are cross-checking whether the cases which are used in that are reliable or whether it is relevant. All those things we are checking, but still our professors are discouraging us regarding the usage of ChatGPT. On the other side, if you see, a lot of advertisements are coming about AI tools for advocates, AI tools for lawyers. And what's your opinion about this, ma'am? And how to deal with this ethical dilemma?
Thank you for raising it. So I'll tell you how I personally handle it. So you should not use ChatGPT as the only resort, right? Like you rightly said, we have to verify. There was an incident that I was discussing with Janaki ma'am when we were traveling from the airport yesterday, that a senior high court lawyer had to apologize before the Supreme Court because an intern used ChatGPT to put together certain precedents, and all of them were fake. Like none of those cases existed, right? It was an embarrassing situation for the lawyer. So we do have to exercise caution because AI is not perfect. We have to verify the information that we get out of AI from multiple sources before we believe in it. That's important. But we cannot avoid using AI, right? Either we can be part of this AI wave or we can be left out by AI wave. Our Harvard professor says that it's not AI that can replace lawyers. It's lawyers who know AI will replace lawyers who do not know AI. Right? We have to be part of the AI wave. We have to learn how to use AI responsibly, but we should also understand it's not perfect and verify the information. There are certain courses that you can take on how you can use better prompts for better results. And in fact, I had a very interesting conversation last week with someone from AI who runs an Abu Dhabi government. He said that forget about prompt engineering. Don't take courses about how you can prompt AI because we have crossed that stage. Use AI for conversational purposes. That is, instead of asking AI as a subservient agent to perform a task, speak with AI. tell AI that I'm going to prepare for this presentation. I think these are the cases that is relevant, and these are the reasons why I think it's relevant. What do you think about it? And how can you add to it? Use it as your own agent who can converse with you, because we can never master the technique of prompting, but we can master the conversational technique with AI, which provides better results when you treat it as an equal, right? And also verify the information that you get from it. So we should all pivot from prompt engineering to a more conversational AI world where we can have a meaningful conversation with AI, if that makes sense. And personally, there are so many ways that you can customize AI. There are settings that is available. My husband also showed me this while we were traveling from Dubai, that I'm a person who would like to take, spade for a spade. I don't like sweet talking. I don't like validation. If you see AI tools, it validates your feelings a lot, right? It always tells you a right. But you can change those settings. If you go to ChatGPT settings and say, straight shoot an answer to me, be honest. I want only verified information. I don't want you to validate my feelings. The results will be drastically different. So we should all take a course on how to responsibly use AI and also master the technique of having a meaningful conversation with AI. That's what I would recommend. But never be not part of the AI wave, right? We do not know what's going to happen in 3-5 years. Everybody is scared of it. So we cannot be left behind in the AI race. And the only way that we can be in the AI race is by learning it. It's a necessary evil, right? We all learn how to use a mobile phone, how to use a computer, how to use a technology. AI is only a tool. We can learn it.
Thank you, ma'am. Thank you for the wonderful and brainstorming session. Now I request
That's a question. I take the last question.
Hi ma'am, I'm Mohit from Government Law College, Dharmaburi. Ma'am, I have some question. Ma'am, in recently, the social media entirely banned in Nepal.
Yes.
So, in the situation made in India, what are the changes in fundamental rights under Article 19?
Sure. If that happens in it, you know what happened in Nepal, right? The entire government was toppled, right, in no time, and people were persecuted and executed in public eye. And that was a huge step by the government, and it was a riot that was waiting to happen, with nepotism and corruption taking over Nepal for so many years, right? If it has to happen in India, you and me can approach the Supreme Court, at least as of today, right, under Article 32, and claim that it violates Article 19, 21 of the Constitution, 14, all of that, right? That right is available to us today. Hopefully, Constitution will not be amended, taking away the rights and just giving it with an irony. But we have that right. It's not Nepal, still a democratic country. Go approach the Supreme Court.
Thank you, ma'am. Thank you for the brainstorming and mind-blowing session. Now I request.
But if it's a girl, I have to take the question. Because never keep your hands down. When they say time is up, keep your hands up. Only people who keep their hands up get their question answered.
I'm Nyadika from Government Law College, Namakkal. The session is awesome and the answer to the question is truly useful to me. And my question is, what do you think about Pegasus software used by Indian government for phone tapping of the greatest minds of India? Thank you.
Very good question. Very great question. Well done. I forgot to mention Pegasus case. So when you all know Pegasus software, right? It's a software that can be only procured by sovereign governments from Israel. Israel has proprietary patent over it, and only it sells to the governments. And India government bought it and employed it against intellectuals and opposition leaders, right? When that case reached Supreme Court, it did not use Puttaswamy. It's a failure, right? All that it said that monitoring orders should be published. Pegasus software can be purchased by the government. All that matters is who it uses against. Unfortunately, it is a very narrow interpretation of Puttaswamy, and it's a failed opportunity to put the government accountable. Yeah, I would say it's a black day, right? Allowing the government to use and not making it accountable is a dire violation of the 9-judge bench decision in Puttaswamy's case. And thank you for pointing it out.
Good morning, ma'am. Good morning. One last question, I will keep it fast and quick. Ma'am, let's put into a situation that you are acting as a committee member or as a member of some recommendations committee, and considering the tendency of cases, adopting AI in judiciary is necessary. So, what would be your suggestions to mitigate the AI bias that is being being in place.
Thank you for raising it. What time is, we almost, okay. Maybe I'll take her question last, if you don't mind, that girls, because she was standing for long, I'll just answer your question first. I think AI should be adopted in judiciary. I listened to a few lectures of Justice Muralidhar and retired Justice Chandrachud. I think AI needs to be incorporated into the judiciary after bias testing, right? If you think about it, AI works on the data that you feed. If you ensure that the data is fair, the results can also be fair. So we should spend substantial time training AI with fair data, with less biases as possible for us to be employed. And if we use that, probably we can dispose more litigations and we can serve justice more quickly than have we today. So I am at the camp which recommends that judiciary should use AI. In fact, I recommend you to read Kerala High Court has drafted some guidelines on how Kerala High Court judiciary or even district court should use AI for their day-to-day work and also for case pendencies. I recommend that you use them. They have few guidelines about how you should never feed AI with privileged communication, but can use it as a tool for research. So I recommend that you read those guidelines published by Kerala High Court judiciary. Yes.
Good morning, ma'am. I'm R. Shweta from Government Law College, Delhi. First of all, I am very thankful, ma'am. Thank you for accepting my question. In this world where AI reaches that drastic growth, the crime related to AI is also increasing, ma'am.
Right.
Where in the case crime solely based on AI, will replace the human testimony, ma'am. Will AI evidence will be equal to the human testimony, ma'am? This is my question, ma'am.
Got it. AI doesn't have a conscious on its own, right? AI cannot have consciousness and empathy like us. But I would suggest a study for you. There was a study that was conducted by Stanford Medical School recently. They compared 100 doctors and AI. AI had more empathy than the 100 doctors, right? AI is also learning to have consciousness and empathy more now, right? I don't see a situation where AI testimony will replace human testimony because who's on trial? AI is not on trial, right? It's human beings who's on trial. But I see AI playing a major role on how we litigate and what type of evidence we submit to the court, and for which an AI regulation is mandatory. We are already behind the game, and I hope the government takes it as a serious step to legislate AI for responsible use and also how it should be used as an evidentiary value. We need amendments to the Indian Evidence Act.
Thank you, ma'am. Thank you for the wonderful and brainstorming session. Now I request Dr. M. Kannapan from Government Law College, Dharmapuri to propose the vote of thanks.